Hi there. My name is Ricardo Chavez. People call me Rax. I am the supervising attorney for landlord-tenant solutions at the law office of Ricardo A. Chavez, Esquire. Our firm focuses on plaintiff-side unlawful detainers, commonly known as eviction cases. We're going to talk about relocation fees in a moment, but first I want to apologize. You can see all the facial fuzz. It's the beginning of October. Next month is November. It's Novembered, a month where we bring up awareness of men's cancer. As a cancer survivor myself, I take a special pleasure in making sure people understand that we need to fight this disease. Talking about relocation fees, they are monies that are paid by the landlord to the tenant so that the tenant can use that to find a new place to live. Very simple idea, relocation fees. Now, these fees can range from a couple $1,000s up to a statutory amount of $21,000, maybe $24,000, depending on the jurisdiction that you're in. And the practice, in my practice as a landlord's representative, I have seen amounts in excess of $100,000 demanded by the tenant's attorney. And that was obviously just a starting number, but people think that they can get a lot more than the statutory amount. And it's your attorney's job to limit the amount you'll pay. Limit your exposure and limit your exposure to just the statutory amounts and balanced against your actual desire to move the tenant. You have to kind of weigh the issues there. And sometimes people really want their tenant gone, so they're willing to pay a little bit more money. You only have to pay relocation expenses when it is a no-fault eviction, which results in permanent displacement of the tenant. Now, there are 5 types of no-fault evictions. I'm going to talk about the first 4. One is an eligible family member, someone that's in your immediate family that you want to move in to occupy the unit so they can have a place to live. This is a no-fault eviction, and because the tenant hasn't done anything, but you are going to be liable to have to pay relocation fees. You're going to withdraw the unit from the market is the second one. Whether it be to convert it to a condo or to sell it as a single family residence, that is a no-fault eviction on the part of the tenant. So therefore you end up having to pay some fees. Then there's also the compliance with a court order. The court order might be because there's some issue with the building itself. Need to empty it out, so you have to comply with that order, and then you of course are going to have to pay the relocation fees. Now, these are all of those are going to be dictated by statutory amounts, and so you might get demands for more, but you don't have to pay more. You have to pay what you negotiate for. There was one other category that used to be a no fault, and that was when you wanted to move a manager into a multi-unit building. That's no longer an eligible qualification for a no fault. There's a subcategory, that's the 5th one that I want to talk about a little bit. And this has to do with the amount of the rent increase. Depending on where you are and how much the rent is and exactly how much you're increasing it are all factors. If there's a 10% of the rent standard, and there's also the consumer price index plus 5% standard. These are things that you need to work out with someone who knows what they're talking about, because you do not want to end up getting into a no-fault eviction because the tenant is leaving due to you increasing the rent beyond those statutory amounts. Now, why don't you have to pay relocation expenses? And that is for what is called a just cause at-fault eviction, which are based on the actions or activities of the renter themselves. Okay? There are at least 13 categories. I'm not going to go over them all. Some of the most prominent ones are, of course, failure to pay the rent, being a physical nuisance, meaning that they're leaving stuff on the property and not removing it, junk cars on the lawn, things like that they refuse to take care of. That's a physical nuisance. Then there's the tenant nuisance, where the tenant is a harassing tenant who's disturbing the peace and quiet of your other tenants, the quiet enjoyment. You might have heard that phrase. The other tenants to be able to not have to worry about this tenant that is disturbing them. Then, of course, there's the refusal to execute a new lease. 99% of the time, you sign a lease and the tenant lives there for a year, and then it just converts to a month-to-month. If you are working in rent control, you're supposed to renew the lease every year, and that lease has got to be recorded. If the tenant refuses to execute a new lease for whatever reason, whether you're in rent control or not, if you want a new lease, and they have to take it. If they don't want to take it, then you can actually move them out, and it's a no-fault just cause eviction. Then another one that happens a lot is what is blocking access to the unit. The tenant makes a complaint about something that needs to get fixed. You bring in a worker can't get in because the tenant won't let them in, and that's blocking access to the unit. And that's something where you have to record the actions of the tenant and have a certain number of times before you actually are able to do it. You can do it on just once, but there's a good faith working that you need to record all of the incidents that take place. All of these things are meant to help limit your exposure to how much relocation fees you have to pay, and that's what my office brings to the table in representing you. So if you need some help with your landlord-tenant solutions, please come to the law office of Ricardo Chavez, and I would look forward to working with you in the future. Thank you very much for listening.